The cool Indiana night air, the crackle of a backyard fire, the comforting scent of burning wood, and the low thrum of a classic song filling the space. It's a scene of domestic tranquility, a perfectly ordinary staycation evening for a married couple. Until in a fleeting, almost imperceptible moment of playful affection a hand reaches out, a brief, consensual touch, and then the world as they knew it shatters. A routine evening morphs into a potential legal nightmare, not because of what was done but because of who was watching. Was it a crime? A public indecency charge for a private moment on private property between consenting adults? The question hung heavy in the air, threatening to unravel a career, a reputation, and the very definition of what is truly private in an increasingly public world. Could a 2-second touch meant only for a husband's eyes land a wife in the crosshairs of the law, potentially branding her a sex offender? Meet Sarah and Tom, a couple in their late 30s living in a quiet suburban neighborhood in Indiana. Sarah, a dedicated social worker, poured her heart into her demanding career, advocating for those often overlooked by society. Tom, an engineer, found solace in the methodical precision of his work. Together they built a life defined by mutual respect, shared laughter, and the quiet rhythm of their daily routines. Their home was their sanctuary, a place where they could unwind, be themselves, and escape the pressures of the outside world. They had invested in a sturdy privacy fence, a deliberate boundary designed to create their own intimate space. This wasn't just about aesthetics, it was about creating a buffer, a literal and metaphorical wall, against the prying eyes of the world, especially those of their next-door neighbor. Mrs. Henderson. Mrs. Henderson, a woman of formidable presence and unwavering conviction, had, for reasons both petty and profound, engaged in a low-intensity, long-running neighborhood feud with Sarah and Tom. Her perceived grievances ranged from the height of their hedges to the volume of their weekend gatherings. This simmering animosity, a constant undercurrent in their lives, often manifested in passive-aggressive acts and thinly veiled accusations, making their privacy fence less a luxury and more a necessity. It was a Saturday evening, a perfect late summer night. Sarah and Tom had planned a relaxing staycation in their own backyard. They had a contained fire pit blazing, its flames dancing under the deepening twilight. The air was mild, conducive to comfort, and a carefully curated playlist of their favorite songs provided the soundtrack to their evening. They sipped their drinks, enjoying the rare luxury of uninterrupted time together. Neither was intoxicated, their minds were clear, their movements steady. As the evening progressed, the playlist shifted, moving into a collection of songs that held special significance for them, tunes that evoked shared memories and playful intimacy. Then it came on: Wars, Low Rider. For some couples, certain songs become shorthand for private moments, a musical cue that speaks volumes without a single word. This was one of those songs for Sarah and Tom. In that moment, caught in the music, the warmth of the fire, and the easy comfort of their companionship, Sarah reached out. Her hand, in a flash, a mere second or two, touched Tom in a deeply personal way, a fleeting gesture of affection, a silent reminder of their bond. It was a private moment intended for her husband's eyes only, a playful intimacy in the sanctity of their fenced-in yard. They couldn't have imagined that this brief, almost imperceptible act occurring within the confines of their own property would ignite a firestorm of legal and social repercussions. All because of an unseen observer. But Mrs. Henderson, it turned out, was watching from her second-story window, a vantage point that overlooked Sarah and Tom's private sanctuary. She had allegedly been observing their evening. Whether by chance or by design, she claimed to have witnessed the brief intimate gesture her Interpretation was immediate and absolute: public indecency. Without hesitation she called the authorities, painting a picture of flagrant impropriety of a couple engaging in lewd acts in full view of their neighbors. The police arrived. Sirens muted their presence, a jarring intrusion into the quiet suburban night. Imagine you are Sarah standing in your own backyard, the smell of wood smoke still clinging to your clothes, only to be confronted by law enforcement, their faces grave, their questions accusatory. The officers duty-bound to investigate listened to Mrs. Henderson's account, then turned to Sarah and Tom. They explained the nature of the complaint: exposure, public indecency. Sarah, reeling from the sudden shift in reality, tried to articulate the context, the brevity, the privacy of the moment. She explained it was on their own property, behind a privacy fence, a consensual act between husband and wife, barely lasting 2 seconds. The officers, however, had a complaint to log, an incident to document. Public indecency laws in Indiana, like in many states, often hinge on the concept of knowingly or intentionally exposing oneself or engaging in sexual conduct in a place where the conduct is likely to be observed by another person. The crucial question became, was their backyard, despite the fence, a public place, or a place likely to be observed? Was Mrs. Henderson's vantage point enough to transform a private act into a public offense? The moral complexity here is immense. On one hand, the right to privacy in one's own home is a cornerstone of personal liberty. On the other, the law attempts to balance this with societal norms and the right of others not to be exposed to unwanted displays. Sarah feared not just a legal penalty but the devastating impact a public indecency charge, especially one potentially escalating to a sex offense, would have on her career as a social worker, a profession built on trust and an impeccable public image. The legal battle had just begun and its implications stretched far beyond a simple backyard dispute. The immediate aftermath was a period of intense anxiety for Sarah and Tom. Sarah in particular was consumed by fear. A social worker's license is contingent upon maintaining a clean record free of any charges that might call into question their judgment, ethics, or moral character. A public indecency conviction, let alone the label of a sex offender, would be a death knell for her career, undoing years of dedicated service and education. They consulted with a lawyer who meticulously reviewed the facts, the Indiana statutes, and the specific circumstances of the complaint. The lawyer explained the nuances of public indecency in Indiana, emphasizing that the key elements often revolve around intent and the reasonable expectation of privacy. Was it intended to be seen? Was it reasonably likely to be seen despite the fence? The fact that Mrs. Henderson had to actively look from a second-story window, seemingly to observe the backyard rather than the act being readily visible from a public street, became a critical point of contention. The defense argued that the fence created a reasonable expectation of privacy and that a 2-second consensual private gesture between spouses not intended for public consumption did not meet the threshold for public indecency. They highlighted the lack of intent to expose themselves to the public and the specific context of an ongoing neighbor dispute, which might suggest a malicious motive for the complaint. The prosecutor, however, had to consider the neighbor's testimony and the letter of the law. The case lingered, a dark cloud over Sarah and Tom's lives, waiting for a decision that could irrevocably alter their future. Ultimately, after careful consideration of the evidence, the specifics of the incident, and the legal arguments presented by Sarah and Tom's attorney, the prosecutor declined to press charges. The case was dropped this resolution while a monumental relief for Sarah and Tom was not a resounding legal victory that set new precedents. It was rather a quiet dismissal based on the ambiguity of the facts and the difficulty of proving intent and lack of reasonable expectation of privacy beyond a reasonable doubt. The prosecutor likely recognized the extreme disproportionality between the alleged act and the potential consequences, particularly for Sarah's career. There was no public trial, no definitive court ruling on whether a 2-second touch behind a privacy fence technically constituted public indecency in Indiana. Instead, it was a decision made in the quiet chambers of the legal system. Acknowledging the complexities of the situation and the inherent challenges in prosecuting such a borderline case. The threat to Sarah's career was averted, her reputation salvaged, but the incident left an indelible mark. The peace of their backyard, once a sanctuary, was forever tainted by the knowledge that unseen eyes might be watching, and that even the most fleeting private moments could be misinterpreted and weaponized. This quiet drama, played out on the stage of a suburban backyard, offers profound reflections on the evolving nature of privacy, the complexities of legal interpretation, and the often unforeseen consequences of neighborly disputes. Firstly, it underscores the precariousness of privacy in the modern age. Despite